All right, well, how many of you had a good time today? Why aren't the rest of you raising your hand? Okay, so obviously we're all here talking about healthcare privacy. So, Deb did a great thing by saying, if we were to bring somebody out here who's actually responsible for some of this, who might it be? And of course, we've got Jocelyn here. So, any problems that you've had with any of your privacy, she'll be able to solve. Of course, that's all in Jeff. She's the head of the Office of Civil Rights within HHS. So it's an enforcement division, and so with that comes certain responsibilities and other responsibilities that you can't really talk about. So my job is to help facilitate this conversation. I'll sit down in a second after I do a quick introduction. But what I'd just like to do is ask you, how many of you know what the Office of Civil Rights is, OCR? All right, so as you start your introductory remarks, you can know that that's the case. And how many of you believe that OCR is doing as much as it possibly can and not any more than it needs to? So there you go. Now you can see that there's some winning over that you need to do. So now what I wanted to do in this latter part of the day here is to really, in all seriousness, ask Jocelyn to talk a lot about what brought her to OCR, what difference does she think she was going to make at an agency. I mean, a government agency can do a lot, but it can't do a lot as well. And some of you have talked about that during the day today. Congress, there's a lot that Congress needs to do, and the feds can only do what Congress allows them to do in many cases. So what I'd like to do is to invite you to ask questions within a few minutes after we set the stage here, and see whatever's bothering you. Anything that she can talk about, she will. Otherwise, I'll tell you if she's not able to, and we'll go to the next questioner. So with that, my name is Shahid. I'm a engineer, so you have one engineer talking to a lawyer here, smart and about privacy. And Jocelyn, nobody had asked me this before, but as we were preparing for this, it was great because I got to spend some time with her. She said, what the heck brought an engineer to privacy? I'm thinking, that's a very, very good question. And really the simple answer is...
I'm going to turn the tables and start questioning him.
So the simple answer is that I got sick and tired of people saying that certain things weren't possible technically. And so basically boiling it down and saying that privacy is not possible in these areas because the technology won't work, etc. And as a guy who writes code for a living, I can tell you the vast majority of those people saying those kinds of things just don't know what they're talking about, or they're lying to you, right? It's going to be one or the other. But at the same time, there's also the alternative where you say, we shouldn't be sharing data because it's not possible to protect it. And that's not true either. So my job, I think, is as an engineer, like most engineers do, is to cut through the BS and say, here's what should work and here's what shouldn't. Now it's up to the lawyers and the policy people and the physicians, et cetera, to decide, okay, what should we actually do? So that's what brought me to the stage. I mean, I'm really more of an engineer who just cares about all of these things. But with that, I'd just love to have Jocelyn talk a little bit about what brought her to OCR, where she thinks OCR is today, and maybe a little bit of description, because a few hands didn't go up. I hope they were not paying attention and they didn't go up. But other than that, we'll take it off from there.
Well, thank you so much. I am so delighted to be here with you, and thank you, Deb, for this invitation. Thank you, Shahid, for engaging in this conversation. Let me start off by saying it is a mark of my willingness to be flexible here that I'm sitting in front of the table, because usually when I sit behind a table, I take my shoes off. So I will try to be a grown-up here and keep them on for the duration of this.
Although this is family, if you want to...
Let me also say OCR is doing a great job. So I'd love to talk about things that you're interested in hearing about. So I thought I'd say a few things first about what brought me to OCR, what some of the initiatives and priorities that I've been working on are. But I really do hope that this will be one of a continuing series of opportunities for dialogue with all of you, because one of the things that is critical to our ability to perform our mission is to hear from those of you on the ground about the issues and the challenges that you're confronting and the kinds of things that are causing concern. One of the ways in which we best do our job is to know what are the real problems and what are the proposed solutions. And that's why I am determined to get Shahid's card after this, because learning what the technical solutions are will be helpful to us. But the Office for Civil Rights has two main portfolios. The first of those is to enforce the laws that bar discrimination by entities that receive funding from the Department of Health and Human Services. So hospitals, other providers, health plans, child care centers, state welfare agencies, as a condition of getting federal funds, they have to agree to prohibit and implement non-discrimination policies that bar discrimination based on race, national origin, age, disability, and in the healthcare context, sex. And so one component of the portfolio of OCR is to enforce those laws. The other component, of course, as you know, is to enforce HIPAA. And we have various tools that we are committed to using. And one of the things that I am really committed to is using the full arsenal of tools that OCR has available to ensure that there are robust protections for the privacy and security of health information. So, for example, we get complaints, and every year we get about 17,000 complaints of HIPAA violations, whether those relate to access or disclosures or other violations of the privacy, security, and breach notification rules. We can also initiate compliance reviews, and these are things that we can start unilaterally on our own. And we do so in response to different kinds of information. So if, for example, there is a particular entity against which numerous complaints have been filed, that's the kind of indicia of potential concerns that might lead us to launch a compliance review. If we get a notification that there has been a breach that affects more than 500 people, we immediately and automatically launch compliance reviews, and we're engaged in compliance reviews of a number of the large breaches that you've heard about over the course of the last several months or so. When we resolve complaints or compliance reviews, we have the authority to enter into corrective action agreements with the entity, and have done that on a number of occasions where we require that the entity adopt policies and procedures, do risk analyses, take risk management steps, do training, and report to us about their levels of compliance with the terms of the corrective action agreement. That's the kind of injunctive relief that we negotiate with covered entities to ensure that they are taking the steps necessary to address the problems that arose on a systemic basis. We also have the authority to impose civil monetary penalties, and have done resolution agreements that include financial recoveries in a number of cases. And you can find all these resolution agreements on our website, and as Adrian heard me say yesterday, our website, not something that Shahid would think was taking advantage of all the technology that it possibly could. But the good news is we are doing a web redesign, and so within 6 months or so, I hope that all of the materials that we have online will be more easily accessible in plain English, comprehensible to non-lawyers and to consumers generally, so that they know what their rights are. But that actually is another component, and an important one, of the work that we do. We provide guidance regulatory analyses, fact sheets, videos, other forms of public education and technical assistance, because we want to get out in front of problems. So it's critical to have a robust level of enforcement activity, because there are serious issues that arise and serious compliance concerns that those reveal. It also sends the message that we will hold entities accountable when they violate the HIPAA standards. At the same time, it's a much better situation if we can ensure voluntary compliance to the maximum extent possible, because that avoids the kinds of breaches that put people's information at risk in the first instance. And so we have provided a lot of guidance material so that individuals understand the protections that are available and the ways in which they can enforce those protections, and so that regulated entities understand what we will expect of them and how we interpret the HIPAA standards. And I encourage all of you to check out the materials that are on our website, because those, I think, are a wealth of documents and other things that are targeted at different audiences and can educate people about the scope of HIPAA protections. The other thing that is really valuable, as I said at the outset, is opportunities like this to engage in dialogue with people out in the community, because we really do want to hear from you about the concerns that you have, the challenges that you're facing, the ways in which you think OCR can best use its resources to address the problems that exist on the ground. One of the ways that we are doing that, that is in process, is we are going to create a portal that will enable initially developers and other entities that are working in new technology to pose questions to us and to let us know what their highest priorities are for guidance, technical assistance, or other information, so that we can ensure that we're using the resources we have to address the problems that are really the highest priority ones on the ground. And it would be terrific to hear from you in, as what I indicated before, I hope will be a continuing dialogue about the ways we can be of help. Let me go back to the beginning and just say, I come from the civil rights world. I was at the Civil Rights Division at the Justice Department before coming to OCR. And so my background is in protecting individuals against discrimination by entities, whether it is employers or educational institutions or housing developers. I regard privacy as, in essence, an extension of the concept of civil rights, because it protects critical consumer rights that are important not only to the individual, but to the proper functioning of the healthcare system. One of the things that Secretary Burwell discusses a lot is delivery system reform, and we really do want to engage in efforts to ensure that we are improving the way in which care is delivered, the treatments that people can receive, and the health outcomes that result. But in order for delivery system reform to really work, people have to engage with their providers, and they have to be involved with their own health care and make decisions about their health care. That requires a level of trust in their providers and a willingness to share information that's really only possible if we have really robust privacy and security protections in place. So I think of this as privacy generally as really an extension of the work that I've done previously in my career. And it's a real pleasure to be able to take on this job, particularly at a time where we're facing serious new challenges. And I think, as all of you are aware, there are obviously multiple new technologies that are posing challenges to the privacy and security of health information. One of the ones that OCR has been working on over the course of the last couple of months is precision medicine. I think you're all aware that the president has announced a precision medicine initiative, which I think has really wonderful potential to improve the way in which we conceptualize disease and treatment and really personalize medicine in a way that will lead to significantly better health outcomes. But one of the things to which this administration is committed is ensuring that privacy protections are built into that system at the outset, and that we embark on this exciting new initiative with a real recognition that ensuring privacy and security as we are developing the data sharing necessary to achieve the medical advances is a critical and component that just cannot be overlooked. And so OCR has been involved with other agencies in looking at the privacy standards that we think ought to apply in the precision medicine context. We'll be looking at where the gaps in the laws are now, if there are any, and what can be done to fill those gaps so that precision medicine, among other emerging technologies, can be implemented to the fullest extent. So let me stop there. Shahid, you probably have other questions, but also I'd encourage questions from any of you.
Yeah, we're going to open up for questions any minute now. So one thing I'd like to ask you is, when you came at a time when Omnibus was just getting released, at least 2013. What do you think about Omnibus from your perspective? About was it a true improvement in the way that data is going to be protected, privacy is going to be protected, or are we just talking about more regs, more laws that really didn't really add to the ecosystem? And the reason why I ask that is, and you're absolutely right, your office is actually quite encouraging and did end up giving developers time. We actually sat and spoke with members of your office when we had questions about Omnibus. We were like, well, who do we ask? Instead of going on forums and chat sites, etc., we just gave them a call, and they're like, sure, have a talk, right? And now, and the reason why I asked about the Omnibus side is when we pose the questions, we ask questions like, okay, I'm a systems developer, can I do this? And after a while it became annoying because the answer that we kept getting back is, here's what the law says. As long as you follow this rule, you should be okay. You know, I'm kind of paraphrasing. I'd love for you to, and you guys explained afterwards, after we had the discussion, about why you give the answers the way that you do. So could you talk a little bit about that, just starting with Omnibus and what you feel about it, and why don't you guys just tell us, can we do this or can we not do that to make life easier, and how would that work?
Let me say first that I think a lawyer's favorite expression is, it depends. You've undoubtedly heard that. But it really does depend on the facts and the circumstances of what data is being collected, who is collecting it, how it's being used, how it's being transmitted. OCR as an enforcement agency is not in the business of certifying, like the Good Housekeeping seal, that certain uses or apps or other protocols are necessarily in compliance with HIPAA. So if anybody tries to market something that says, OCR says this is HIPAA compliant, that's a misrepresentation of what our role is. We're an enforcement agency, and we interpret and enforce the standards of the law. Now, what does that mean? HIPAA, the statute, sets certain parameters, and we are not, as the administrative agency charged with enforcing it, authorized to go beyond those. Some modifications have to be done by statute, as I think the previous panel was remarking. On the other hand, as a regulatory agency, we have the authority and I think the responsibility to interpret the standards that exist in the statute, and that's what we've done in the privacy and the security and the breach notification rules and in our sub-regulatory guidance as well. Now, let me just say a couple things about the omnibus rule. I think that extending direct liability to business associates was a significant change in the landscape, and a number, for example, of the breach notifications that we've gotten have come from business associates, and giving us the ability to enforce directly against them has been an expansion of the universe of regulated entities that I think is very helpful. I think there have been other clarifications through the omnibus rule and through high tech that have been helpful in enabling us to take steps to address some of the then pending privacy and security concerns. That said, the world has changed a lot in 6 years, as you all know, and I think there are continuing issues and challenges that arise. And that's one of the reasons that we're developing this portal, so that we can gain a better understanding of what are the things that are going on in the world outside, and are the HIPAA standards as we currently apply them sufficient to address those? Is it just a question of taking the standards that we, I hope, explain pretty clearly in our material and applying them to new factual scenarios? Or are there ways in which we need to think about expansion of the different laws that govern privacy? And I guess one thing I would add to this is, as you all know, HIPAA is a very specific framework for protection of privacy and security of health information. So it applies to specific categories of entities. It protects particular kinds of information. There are other laws and policies that also regulate privacy that we don't enforce, but we work very closely with other agencies to ensure that we're all moving in sync and applying consistent standards. So, for example, we work with ONC all the time. They are very close collaborators, and we have worked very closely on a number of the guides and documents they have issued, including the data blocking report, including the privacy and security guide. We work with the FTC because they have the authority to ensure that corporations basically adhere to the commitments that they make in their own documents, and those include privacy commitments. So OCR is one of a number of entities that has some responsibility for ensuring privacy and security. There are obviously laws that apply to banking entities that have nothing to do with health privacy. So we're part of a larger enterprise, and we all talk to each other, try to share good ideas and best practices, but at the end of the day, our job is to enforce the law that we have. And so HIPAA sets the boundaries of what OCR's authority is.
So we're going to play. Oh, that's right. I think Adrian had a question. Oh, yes. Okay, go ahead. So we're going to start the Stump the Jocelyn part of the show.
Thanks so much.
Hi, thank you for being here.
Sure.
So I wanted to ask a little bit.
Can you just identify yourselves when you ask questions? It'd be great for me to know who you are.
My name is Ben West. I'm an internet researcher. I help with a project called 90Cat. So I wanted to ask about the tension that we've been discussing all day today about the difference between sharing data and protecting it at the same time, right? And so HIPAA is about both of those things, portability and access, as much as protection. And so I wanted to ask you about troubles that you may have, limits that have been placed around your ability to do those things, particularly when it comes to new technology that gets developed. A favorite your data, you're getting access to it through our copyright, and so you don't have permission to do that. And in fact, recently with the 1201 copyright DMCA hearing, they go a step further and say we've engineered our system such that it's got patient data on it, and if you do get access to it, you're now causing us to violate HIPAA because we've lost control of those patient records. So I'm curious how you tackle that.
So did everyone hear the question? So Ben was asking both about the tension between data sharing and access and privacy protections, and in particular about vendors who will say that their systems are copyrighted or that sharing data would violate HIPAA. And I would say these are problems that are actually addressed in ONC's data blocking report. And if you haven't taken a look at that, I'd encourage you to do so. It's on healthit.gov. Basically, ONC was commanded by Congress to do this report, and it looks at situations in which entities refuse to share data with people who are entitled to get it, like patients themselves, on various bases, like it's prohibited by HIPAA, or it's will put them at a competitive disadvantage. It's a serious problem. I would say we are very committed to enforcing patient rights to access. And one of the things that we have done over the course of the last year or so is to expand rights to access in several ways. So we've issued improvements to make clear, to facilitate patient access to electronic records. We also, under CLIA, recently finalized the rule that allows patients to get data directly from labs as opposed to through their providers. We are working very closely with ONC on ways to address the situation when a covered entity says that it would violate HIPAA for it to share data with the patient or provide data to another provider from whom the patient wants to seek a second opinion. We are absolutely available to educate people about what HIPAA does and does not prohibit and what the permissions in HIPAA are. And to the extent that entities are denying access on grounds that either are based on a misunderstanding or a misrepresentation of what HIPAA requires or permits, that's something that we'd be happy to address. And to the extent that any of you encounter that, you should consider filing complaints with us. We have an online portal where you can do so. And when we get complaints, we take a look at them, figure out what's going on, and have the authority to seek relief if we find that there are sources of concern.
Great. Adrian?
Hi. I have a roundabout engineering question.
That would be Shahid's.
Yes, either one of you can answer, but I doubt it. But it's only roundabout engineering. It actually also builds upon Ben's question that you just answered, and it has to do with the relationship between OCR and ONC. ONC is effectively in charge of the engineering issues whereas we've already heard your role. And I want to be very specific here and refer to the end of the last panel where Joy was addressed this issue you yourself also addressed of the gaps. And we addressed it in the context of whether TPO might or might not be rolled back as part of Precision Medicine Initiative and 21st Century Cures and whatever this new round of legislation is likely to come. And the question, the technical engineering question between you and ONC has to do with accounting for disclosures. So as a hedge on what we all hope doesn't happen, that TPO gets extended, what can be done between ONC and OCR to introduce the protection, which I think Deborah can describe how we got here, that was meant to be in HIPAA around accounting for disclosures, and the fact that it's considered to be too hard, and frankly, ONC has not done anything about to deal with what's too hard in that sense. Thank you.
So the question is about accounting for disclosures and how to work with ONC to ensure that there are mechanisms in place to ensure that patients can exercise their rights to get an accounting. I think Adrian also is talking about potential expansions of the TPO exemptions from consent. Let me talk first about accounting for disclosures. As you know, we put out an NPRM before my time, a year ago maybe, to say that we got robust comment might understate the level of interest and divergence of opinions that we got through the public comments we received. We are in the process of analyzing those and will be moving forward in the rulemaking process. I think that we may choose to issue another ANPRM to solicit information on particular issues, but that's something that we are looking at, and of course are conscious of the requirement in high tech that we move this forward. With regard to expansions of TPO, you know, as I said, OCR enforces the law as it is. Should the law be changed, we'll enforce the law that results. We are, of course, like many of you in the room, monitoring what is going on the Hill, and you know, are aware of some of the legislative proposals that have been made to expand authorization for research and other activities. You know, at some point in time, I think the administration will likely be asked for its position on some of the legislative initiatives, and that's a process that the government as a whole will engage in. I guess what I would say, and this goes back to Ben's question a little bit, is I think that it is something of a false dichotomy to think that privacy and data sharing or innovation are always in tension. Because, as I mentioned earlier, I think having robust privacy protections embedded in innovative technologies is critical to ensuring that they can achieve the goals that animate all of the work. So people will only engage with the healthcare system if they have adequate protections for this very sensitive information. So I don't want to set this up as you know, a zero-sum game where in order to get privacy, you have to abandon data sharing, or in order to do data sharing, you have to abandon privacy. I really think that it is possible to do both. And that's one of the enterprises that we are trying to do in, for example, the context of precision medicine, where deriving privacy principles that ought to govern this exciting new technology is an integral part of what the initiative is all about.
So are there other questions? There's another question. Go ahead.
Yeah, I'm Lucy Thompson. Thank you, Jocelyn, for talking to us. I'm a former DOJ Main Justice Fraud Prosecutor, and now I work as an engineer, and I specialize in cybersecurity and privacy. And watching the health sector rise to the top of all the industries in terms of data breaches, and looking at the FTC and how they've taken a really cutting-edge role in going after these companies that are having the breaches, do you have the resources to be able to ramp up to deal with all the breaches that really need to be addressed at this point?
It's good to see two lawyers talking to each other. I really like that.
No, thank you for that question. It was about our resources and whether we have what it takes to ramp up the work to meet current challenges. I did not set that up. Look, we face real resource constraints, as do other government agencies, and I don't want to hide the ball on that. That said, we are really trying to streamline our operations and institute new reforms that will enable us to use the resources that we do have to best advantage. So, for example, we have created something called the Centralized Case Management Operation, which is a centralized system that we use to evaluate complaints as they come in, so that there is a cadre of people who examine each of these complaints, identify those that are going to require more investigation, and forward those to our regional offices for more in-depth evaluation, whereas they can provide technical assistance or enter into corrective action agreements that are more straightforward for situations that pose more easily addressable concerns. We also have been trying to create technological improvements like smart screens that will enable people to identify whether our OCR is the right place or whether in fact their complaints can better be addressed by other enforcement agencies in the government. We are also doing a lot more with online access. So, for example, we now have a breach data portal so that entities can give us their documents electronically, which not only, I think, creates more efficiencies for them, but also creates efficiencies for us in having access to the documents, being able to search them and look at them electronically. So we are doing the best we can. I think that one of the reasons that we automatically launch compliance reviews of breach investigations that affect more than 500 people is because those are the kinds of cases that are most likely to have involved some kind of systemic failure that is something that can be addressed and benefit significant numbers of patients and other individuals. We also are moving forward with phase 2 of our audit program. And I know that a lot of you in the room have heard me say this before, but it's coming, and it's coming soon. We look at audit as a really valuable new tool to once again get out in front of potential problems and identify compliance concerns before they result in breaches. And the way in which we plan to conduct these is to undertake really sort of systemic evaluations of compliance with different components of the privacy and security rules, and work with entities to ensure that not only they are addressing the particular problems that we identify in their operations, if we do identify them, but also so that we can get a sense of what some of the common issues are and better target the technical assistance and guidance that we provide. So I think, again, we're trying to do more with less. We're trying to use our resources in the most impactful way. And I think the audit program will enable us to identify and target practices that are having an impact across industries in ways that can ultimately be a very beneficial investment.
And as the next questioner is coming up, are the audits just focused on CEs, or are you guys going to start auditing BAs directly?
We are, one of the things that you should tune into our website, which, as I said, will be being improved, but we will be posting the protocol for the audits before the program begins, and that will give you some greater information and texture to the way in which we are conducting these. But our plan is to take a sampling of different entities within the healthcare world so that we can ensure that we're identifying problems that may be plaguing particular sectors, particular regions, particular sizes of entities. So I think our goal is to be pretty broad-based in evaluating the universe of entities that we would work with.
We've got about 5 minutes, so next question.
Okay, sure. I'm Craig Conant from Penn Law School. Hi, Jocelyn.
Hello.
So the previous question was about resources. That was a great segue into my question, which is about authority, right? So to the extent you can talk about it, in what ways would you like to see statutory modifications happen so that your authority would be extended? Where do you see the gaps, if any, as you said earlier? But if you do see gaps, where do you see them? And specifically, a couple of the gaps that I think have been referred to, a couple of common themes that come up in this conference on a regular basis is, the entities that are covered are too few, and the kinds of data that are covered is also too limited. So how would you expand the definition or change the definition of covered entities, and how would you define, if you could, medical data? Thank you.
I thought you were my friend. Craig's question was about, what kinds of statutory changes would I like to see in HIPAA or in privacy protections? And let me say up front, I'm not authorized to speak on behalf of the administration on this question, but I will say the following. HIPAA was enacted 2 decades ago when the healthcare world was different. And as you note, the way in which it conceptualizes the privacy framework is by covered entity. Whether that is adequate to address emerging challenges is, I think, a question that is under significant debate and consideration on the Hill, in the stakeholder community, in the administration with regard to precision medicine. Whether there are gaps that need to be filled, I think, is something that will be identified as a result of these kinds of collaborative consideration processes where we identify what are the threats and do we have the tools to meet them. One of the things that ONC was required under HITECH to do was a report on non-covered entities that I think will be quite informative about the ways in which there are entities that are currently engaged in the healthcare space but not covered under HIPAA's protections. And I think that that's the kind of analysis that will inform this debate going forward.
Great. Other questions?
Sorry. Hi, I'm Vanessa McKenzie. Please give my regards to Kurt Templet, OCR, and Eliana.
I will.
Thank you. I do have a quick question about the lack of technological interoperability. So how do you foresee OCR handling that? And I don't want to call vendor names, but it's becoming a larger problem. So what's your stance on that now, or will you be issuing guidance soon?
On interoperability?
Yes.
So that is ONC's big mission, and I suspect that many of you have seen the roadmap that ONC issued in the winter sometime, which identifies the steps that they will take toward interoperability. That's obviously a critical component of making electronic health records a workable system and delivery system reform, and we consult very closely with them to ensure that privacy protections are incorporated into steps to create interoperability, but it's not something that is directly within the OCR portfolio.
Hey, just a quick question. How many of you guys saw the data blocking report? About half of you. So anybody who didn't, definitely check that out. Were you involved? Was OCR involved?
We collaborate, and sort of any report that comes out of the government is one that has gone through a process of clearance and evaluation, because I think the government wants to make sure that all of its different equities are considered.
Mm-hmm.
So,
and with that, and basically what she's saying is it's a pain in the ass to get reports out of the government. And the fact that that data blocking report came out, it says volumes just by itself, right? And I think to the last question, definitely check that report out, because it doesn't have any remedies in there just yet about what they should do, but it's definitely the conversation starter to get that going. Go ahead, next question.
I think this is going to be the last question. It's going to be really easy. So my name is Tatiana Misek, and I work for a company called CNSI, and we build technical solutions for Medicaid, state Medicaid agencies, and CMS, and we process a lot of the healthcare claims. So I'm in the process of building a business case for implementation of the Privacy by Design framework for my company, and so one of the questions I have is HHS going to like FTC, that has privacy by design as one of its recommendations, and actually companies that sometimes have to implement as a result of the FTC's involvement and so on. So do you see HHS promoting something like privacy by design? I know that NIST is looking into it and had a lot of had a whole day committed to it, and is looking and is issuing or has issued public comment period or a public comment request about privacy engineering and privacy design and so on. So I'd like to see what your thoughts are on frameworks like this. Thank you.
No, thank you for the question. And NIST is another partner that we collaborate with very closely. I'd love to learn more about privacy by design, because I frankly am not an expert in that. But certainly, if there are technological ways to build in privacy from the outset, that is something that I think animates a lot of the government's work on new initiatives to ensure that these kinds of protections get embedded.
Absolutely. So Privacy by Design is a framework that actually promotes and helps organizations build privacy and protect privacy from the onset as a default. And so it doesn't prescribe the solutions, but it really helps organizations kind of come up with a framework where privacy, both in terms of the policies and documents and procedures and so on, as well as in, when they build how to, it helps understand how to build the requirements early on in the systems development lifecycle.
Thank you. That's very interesting to hear.
If I could follow on exactly
Yep,
this. Earlier this morning, we had a keynote that talked about Japan taking a middle way between sectoral regulations of privacy and rights-based. Not maybe civil rights is the closest to that in the European data protection. Relative to exactly this question that you were addressing, and the NIST has released excellent work, really excellent work, very recently, last week most recently, that's almost quantitative. It is semi-quantitative in terms of doing this privacy engineering work. Now that this kind of thing is available, or it's in draft NPRM status, is your office in a position to play a middle ground? In other words, within the scope of HIPAA, to act as a data protection authority within the sector called health?
So I'm not sure if I am understanding your question. Go ahead. Did you want to?
No.
I mean, fundamentally, we interact with a number of other government agencies, because as I mentioned before, there are interlocking protections, and while the jurisdiction of each entity is a little bit different, we can provide a stronger network of protections by working together than any of us can on our own. HIPAA is what HIPAA is, and so we are committed to using the tools that the law gives us to the fullest extent of the authority that we have. Obviously, we can't go beyond what we're statutorily authorized to do, but to the extent that our experience can help to inform the kinds of policies that are coming out of other parts of the government to ensure that they also consider privacy considerations in the context of their work, we obviously are happy to be of help.
NIST is famously not a regulatory authority, and you are an enforcement authority. So does this now mean it has to go to ONC?
I guess, we do put out NIST standards for some of our work. So it is, they are the standard setting entity, and we collaborate with them at the front end so that the standards are ones that are sufficiently protective. We also work with ONC to ensure that what they are doing to promote interoperability contains adequate privacy protections, and to the extent that, for example, meaningful use requirements superimpose additional requirements on entities that take advantage of the financial incentives. Those are things that we've discussed with them to ensure that they adequately protect the privacy interests that we all share.
So we are a couple of minutes over time already, so if I'll welcome you to check with her after we get done. But what I wanted to do is to give you 30 seconds from a summary perspective to just let us know. This is a pretty active community, as you can see, and their questions are beautiful and right to the point. What could this audience do to help you guys out to do your job better? Because you do have resource constraints. So,
well, no, I appreciate that question, and. It's a terrific question, because there is a lot that you can do to help us do our job. One thing is to let us know what you're hearing. Where are there issues that you think we ought to address? What kinds of problems are people encountering in getting access to their health data, in disclosures that are impermissible under HIPAA? In addition, what are your ideas about additional guidance that we could issue that would be helpful in enabling covered entities and business associates to do a better job of protecting privacy and security rights? Are there ways in which we can provide technical assistance? Is there public education that we can be doing in order to ensure that people know what their rights are and that we exist? Often I go into rooms and I say I work for OCR, and I get this kind of slack-jawed, never heard of you, what are you? So we need to do a better job in getting the word out about what our authorities are, what our tools are, and what people's rights are, and I welcome your suggestions for how we can better do that. And I'd also say, it's been wonderful to have this dialogue. Thank you for your questions, which are really thought-provoking and insightful, and I really do look forward to continuing the conversation.
All right, big round of applause.